Sir is a retired civil servant from Central Secretariat Service, 1988. He worked as Joint Secretary, Department of Justice, Ministry of Law and Justice since January 2017. He was also Mission Director for the National Mission for Justice Delivery and Legal Reforms. He took initiatives for implementing policy reforms for improving enforcing contract parameters under the Ease of Doing Business and E-Courts project. Earlier, he was a Joint Secretary in the Department of Industrial Policy and Promotion, Ministry of Commerce and Industry, Government of India, New Delhi, where he contributed various FTA negotiations and RCEF agreement. There, he also held additional charge of Director General, National Productivity Council from December 2015 to May 2016. He is a former Registrar of Copyrights of the Indian Copyright Office, where he played a key role in introduction of the recent amendments to the Copyright Act in the year 2012 and the Copyright Rules 2013. He has attended many WIPO, SCCR meetings and FTA negotiations as a member of Indian delegation. He has made significant contributions to recently concluded two WIPO treaties, namely Beijing Treaty on Audiovisual Performances 2012 and the Marrakesh Treaty to facilitate access to public published works for persons who are blind, visually impaired, or otherwise print disabled 2013. He has contributed in the revision of copyright legislations of Bhutan, Cambodia, Myanmar, and Nepal as a copyright expert. As a resource person, he gives lectures and talks on copyrights and related rights in various international and national seminars and workshops organized by WIPO and by several law schools, universities, and institutes all over India. He has recently been awarded a PhD IPR from GSSIP University, New Delhi. He holds several degrees and postgraduate degrees, namely a MA in Development Studies, Public Policy and Management from the Institute of Social Studies, The Hague, the Netherlands. He also has an MA in Gold Medalist and MPhil in Ancient History and Archaeology from Osmania University, Hyderabad. He was a JRF scholar of UGC as well. He holds an LLB degree from the Delhi University and LLM and IPR from GSSIP University, New Delhi. He's completed his bachelor's and degree in library science and information. So this was a brief introduction. I pass it over to you for this session. Thank you very much, sir. We are very delighted to have you, sir, today with us.
And thank you, Tanvi, for your generous and exhaustive introduction about me. And Hare Srinivasa, Vande Mataram, I would like to thank Dr. Pal Thore of Nagpur University and inviting me to share my thoughts on the most important issues, that is various emerging digital technologies and intellectual property rights. Understand that it is a pre-PhD level interaction. So I'm not going to give a lecture and PPT and all that, knowing that. So I'll just interact with you, which are the most emerging hot topics. You know, you can venture into and do research and just uh, leave an imprint on that topic. That's what I have done. 5 years ago, when I joined, I was hovering between the traditional copyright or patent issues. I was thinking about access to medicines as one of my research topics and music issues, royalties issues, which I address most of them uh, in the drafting of the Copyright Amendment Bill 2012, which was passed by Parliament unanimously. And one more hot issue, that is the copyright societies. Then a friend of mine, American Copyright Office, met me over a cup of coffee in New Delhi when delegation came. He said, what India is doing in text data mining. And as I said, we have not done anything. We have already missed the bus 2012. And we are just watching. At the time, AI was also knocking. I remember Niti Ayog had come with a national AI strategy paper. It's available on Niti Ayog's website. how the various departments into the digital thing have to come together and work. And the moment AI, is still emerging and getting in, it's not leaving any field. And apart from AI, another area where government of India was, I'm talking about the period of 2015, 16, 17, 18. These are the 3, 4 years where too much thinking was going on my brain, which topic to be taken. I was choosing one, leaving one, like that. And then happened the industry 4.0. At a big level, industry 4.0 discussions were taking place in the ministries. And, uh, I was a director, then become a joint secretary in the Ministry and Commerce Industry. That's especially the Department for Promotion of Industry and Internal Trade, which you call it DPIIT. And 3D technology, that is another field where it is impacting not only the patent law, design law, and copyright law. Upon the industry 4.0, those who are not aware about this, what is this technology? No, mostly the manufacturing, right from the Industrial Revolution, when the new technology was introduced in the 16th century UK, it was spread to entire EU. It is man to machine manufacturing. Various machines were introduced for manufacturing uh, at the huge level. So various manufacturing units were set up, and many laborers thought that these machines are going to replace us. And then few people, there was a movement called Luddite movement with all the big hammers. They used to go and break, dismantle those machines because they may, take away our employment. I remember when I joined finance ministry in the World Bank division, with the World Bank help, we got a entire department automation. That task was given to me. When I received, huge number of computers, I remember how the people were scared that their technology is going to replace them. They will lose jobs. No. Now you hear the same thing when the industry 4.0 manufacturing is coming, that is machine to machine manufacturing happening. Then where is the role for man, human being? But that man will always be there to handle these issues. So he'll be employed in a different thing. So what are the laws associated with this? The present laws, when to man to machine manufacturing happening, when machine to machine happens. So what kind of law, what kind of regulation has to be there? This can be one beautiful topic. Then we have the data creation. The latest data protection bill has been introduced in the parliament, and this is in replacement to the old bill. Data protection has become very, very important. This is another area one can concentrate. When uh, Europe introduced GDPR, that is General Data Protection Regulation, many countries try to ape that. So many, even India also, people were talking about what government is doing. Why can't they adopt a ready-made law available? 28 EU nations have adopted and all that. So finally, there was a great judgment given by Supreme Court during that period. That is famous Puttaswamy judgment. You are all aware of that. And also it was followed by the Aadhaar judgment. The both are related to the data privacy. How the data has to be, personal data has to be protected, data privacy has to be protected, which Supreme Court said this data privacy, the human rights, the fundamental rights, is nothing equivalent to the privacy of the human being, and this data equivalent to right to life and personal liberty. Then it gave a direction to the central government. Oh, please introduce a law for data protection. So government was already thinking of that. They appointed Justice, um, what is a committee. I'm just he's a friend of mine. I know him, but I'm just suddenly forgot about. And a Sri Krishna committee. Sorry, Justice Sri Krishna committee uh, appointed. He gave a very good report, Justice Sri Krishna, and that was that report helped drafting a first legislation. Of course, few cherry picking work also they have done in the law, not only the recommendation of the Justice Sri Krishna Commission report, also the GPR regulations which were suitable to India was included. But when, as you know, that how the laws are made in India, when first the stakeholders discussions takes place in the government, um, and whether the model may be the bottoms up approach or the top down approach. Top down, normally the cabinet or the minister decide that particular law need to be introduced. Sometimes bottom up happens. The people like you do research uh, and to submit a report. Based on that, laws are introduced. So various stakeholder discussion is very, very important in the lawmaking. And a committee will be decided, various experts are interactions will happen, points are jotted down, and a drafting committee. Out of this committee, few relevant bureaucrat from the civil servant who are administering this subject, that particular ministry, and also come the line ministries, maybe the law ministry or any other ministry. Like industry for manufacturing, heavy industry come, commerce and industry will come. Similarly, data protection law means IT ministry come, and other related ministries also come. And here what happens, the draft is prepared and shared with the members of that uh, main stakeholders committee. And but with their comments and all that, a shape is given to that. It put into a draft legal bill form, and this draft bill is submitted to the legislative department where they redraft this into typical legislative language, whether what could be the definitions, what could be the, whether a non-obstante clause is required, whether the actual drafting is good. So when international law or some multilateral law is adopted, how it has to reflect, whether it is relevant or not. So all these things legislative department redrafts, then that is approved by the minister with a cabinet note is made, and this draft bill and cabinet note is circulated to all the ministries and departments. Normally given 15 days time, and the comments are included, and the relevant ministries comments may be accepted or rejected, but that need to be logically, rationally explained if you are accepting or rejecting those recommendations of the line departments or ministries. With that statement, with that cabinet note and the draft bill submitted before the cabinet, chaired by the PM, they approved it. Whatever some changes they want to introduce. Finally, the minister, once the cabinet approval comes, he introduces the bill in the, if it is not a money bill in the Rajya Sabha, if it is a money bill, Lok Sabha. The entire concept, the intention, legislative intention of introducing this law is put in the uh, statement of objects and reasons. So, like this, the laws are made. And data protection law, which I was talking about, once it is introduced in the parliament, 99% these bills are referred to the department related standing committee of the parliament, in which the members of both Rajya Sabha and Lok Sabha are included. One senior most person is the chairman who has knowledge in this area. And they examine, they conduct various interactions with the ministry. Not only with the ministry, they release an advertisement in newspaper, Rajya Sabha Secretariat normally, calling experts like you, a general public or industry and other stakeholders, please give your relevant suggestions, any of the provision of the bill. Look at how importance of the comments and importance of that stakeholder who are relevant. Uh, they are called for the one-to-one interaction. Normally, the standing committee calls groups of people, stakeholders, and interact with them, further discuss what comments they have given, that is discussed in detail. So finally, once these discussions are concluded, the committee prepares its report. They sit down and final discussion with the concerned ministry. And minister nowhere is involved in this matter. Only the secretary and senior officers like me to go and interact with the department related parliamentary committee. Finally, they submit that report again in the Rajya Sabha. That is tabled. Okay, once that is tabled, actually that is not mandatory. Whatever suggestions are given, mandatory on the minister or the concerned ministry to accept all the recommendations. It is only advisory in nature. So the concerned minister may decide, I'll simply ignore everything and go with the original bill I have introduced. Or he might, the department might accept some recommendations and amend the bill, or accept many things. If amending the bill means, again the ministry has to go through the same process. They have to go to cabinet with the amendment to the bill. Again, legislative department helps them in creating that amendment bill. Cabinet approved. This amendment bill is inserted in the already placed bill on the table of the Rajya Sabha. So it may be accepting few things, which is suggestions came from. But here, what happened in the data protection bill? There were more than 80 recommendations. So huge overall of the bill has to be introduced. So wisely, the current IT minister, Ashwini Vaishnavji, he withdrew the bill. And they drafted the new bill, the cabinet approval has been, that has been introduced now. Now you see the kind of thing happening. Recently, government one guidelines they issue to the markets. When you go and buy a cup of coffee and a cafe coffee day or a Starbucks, when you're making payment cash or using your card or making a UPI payment, scanning through your app, they said, what's your telephone number? Then that's it. Telephone number they got, it means entire your personal data is gone to them. And that data is stored by them illegally they're sharing with other people. In fact, they're selling that database. And that is the reason why you keep getting at least 10 calls per day. Average, I get 10 calls. I keep blocking those calls. Either these are the marketing commercial call, ye le lo, o le lo, or remaining spam calls or fraud calls. Nowadays, it has become dangerous. If you get any SMS, clicking the link or opening that, and you're getting a WhatsApp calls. There are many nasty frauds also started with it. Digital India program, the policy of the government, that is the big thing happened. Even world over, people have raised their eyebrows how India could manage so successfully creation of Aadhaar. Those who are interested in this kind of area, the Digital India program, how the entire things, where you see, earlier I remember 10 years back, I used to stand in various, there Saturday used to go in going to stand in the queue. Landline telephone bill, I have to stand in the queue. My Vodafone bill, mobile bill, I have to stand in the queue. Electricity bill, all the bill, entire Saturday gone. And sitting in my drawing room or anytime I can pay my bills with a click of the button. And UPI came. Many opposition leaders, they mocked Digital India program and Honorable Narendra Modi that sabji wala 20 रुपए कुछ सब्जी बेच रहा है उसको यूपीआई कर दोगे क्या? You see in the market now how digitization has spread even villages. I don't carry any cash. I carry only 100, 200 rupees in case of urgency, either card or UPI payments I make. So entire transformation has happened. So it can be an area where how law, regulation, and related frauds and all that. This is another area of research you people can do. Of course, the data protection law and privacy. Most important thing is, you have a stomach upset. You don't want to go for the allopathic medicine. You search for some alternative medicine, whether it is Ayurvedic or homeopathy. And since you are not having much knowledge which medicine you have to take, homeopathic medicine or Ayurvedic, you leave it. You are not convinced. Then let's go and see how my friends are reacting to my earlier post in Facebook. The moment you go to the Facebook, your specific advertisement targeting you are coming. Either homeopathic medicine for your stomach, or the Ayurvedic medicine. Various company advertisements specifically meant for you being dished out on your Facebook profile. When you are browsing, all these ads are coming. You test, you search for anything in the world. You go and search for some typical product on the Google. Go back to social media, especially Facebook. You see, those advertisements are coming. So why there should be a compromise of your privacy? So that is very important. The data protection bill going to address. Then coming to the most important area, the most emerging area. I'm going to touch AI later because I know my friend Raman Mittal has just ended AI. I'm not going to discuss in detail about that, but the various aspects I'm touching. I was mentioning about the industry 4.0 manufacturing. It is going to be transformed with introduction of AI. Entire manufacturing is going to change. The way you have data about the suppliers, your market related data, everything to be managed by artificial intelligence. And coming to the other areas, which is mostly, can you hear me?
Yes, sir.
Yes,
Yes,
sir.
sir. Yes,
Yes,
sir.
Yeah,
sir.
yeah.
Yes, sir.
That is mostly of mm, uh, the manufacturing and the marketing areas, especially the service areas, the fintech areas. So, how the fintech law, that is another important area, may not be much research has taken place. The fintech law is very, very important. I remember when it was in 2018 when I visited St. Petersburg, international law uh, conference. 140 countries were there. There were three special sessions on Finetech only. What, in Finetech, whether you can apply the current civil procedures, criminal procedures, what are the other kind of regulation has to be done. Now, the way it has been introduced in India, you know, very appreciably introduced by the Modi government since 2014. What they have done, they followed sandbox model. Those are not aware what is a sandbox. Sandbox is just like a small project containing in one particular area where trial and error basis innovation takes place. So whatever is succeeding, getting impressive, giving good results, so that innovation is adopted and try to spread in other areas, other jurisdictions. So basic exercise is taken in this particular sandbox. They selected some banking institutions, financial institutions, non-financial institutions, uh, um, whatever. In particular city, they did the sandbox experiment. They succeeded. Then now you see the Finetech is ruling in India everywhere. So this, when you do the take up the other area, similarly, maybe the artificial intelligence regulation. There is no regulation now. US uh, policymakers are still breaking their head. All the important key departments, whether USPTO, US Copyright Office, and other uh, the major ministries of the US State Department, doing interactive sessions with the experts and various stakeholders. Still discussion stage. But EU already one step or 10 step ahead. Similar the way they have done for the data protection with the introduction of general data protection regulation GDPR, they're coming out with AI Act. The draft AI Act is ready with them. We are simply thinking that maybe our Digital India Act, which is being drafted in the IT department, maybe trying to address these regulation issues. Whereas EU has already done, the draft has been released. I mark my words, end of this year 2023, EU Parliament will pass this AI Artificial Intelligence Regulation Act. And the other 28 EU member states will be jumping to introduce this. EU, there is a kind of harmony among their of laws. You take whether it is patent laws or copyright laws and the data protection laws, any law, there is a harmony in all EU states. Even they recently introduced the patent examination. Recently, they have introduced unitary patent law. So whatever patent examination happens, the way it is examined in the UK or Spain or Germany or Sweden or Portugal or Italy should be the same methodology, steps to be followed. And the granting of patent should follow the same process, the unitary patent they have introduced. And, and then you may get a doubt. We have four major patent offices uh, for the jurisdiction wise. You have Chennai office, Delhi office, and Kolkata office, and Mumbai office. Are they examining in the same way the patent examination or a trademark examination? Why there is a difference in the time taken in these jurisdictions? These things can be one area of your research. You may give your own suggestions or comparing with the unitary patent law of the EU. So this can be one area of research. Then you have the AI and manufacturing totally changing. And when Industry 4.0 coming, there is another associated technology which has already come, which is being adapted in a soundbox models, IoT, Internet of Things. Internet of Things comes, sitting here, I'm lecturing you, you guys are listening to me, but suddenly your mind goes whether I switched off my AC in the other room, or my car lights are still on. I maybe forgot. So my washing machine is still running. I have to switch it off. All these things, Internet of Things, going to change. You open the fridge door, I forgot to close it. Okay, all this game, the information will coming, either talking to you, I may switch off, either you listening to me, I may do. But here, not only this thing, adopting the technology here, again, humongous data is going to be taken out of that. No human being is similar, their behavior. Even Bhagavad Gita talks about three gunas: Sattva guna, Rajas guna, and Tamas guna. We're all like that. Your own brother or your own sister don't behave like you. Their likes and dislikes are different. But Facebook knows more about you. Google knows more about you than your sister and your parents, because many things you don't tell your friends and your siblings or parents what you like. Few things they may know that rajma chawal is your favorite dish. Your mother may cook it, but various other things Google and Facebook knows which they may not be knowing. So that data is created. Similarly here, the way what are you storing in the fridge, what kind of clothes you buy, or online, or you what kind of the washing powder or the washing things you use in a washing machine. Various kind of data is created, and those advertisements keep coming to you, and these guys create this data and they market it. you know this is going to be a big problem in the uh, 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 regulation. So laws have to be doing that. And then if you see the AI regulation issues, AI is used in health sector. You know, then there is surgery or a treatment. That everything is surgery is not an issue, but basically diagnosis, then by treatment. Then treatment won't give us. There may be possibility of a surgery is surgery. Whether surgeon going to be a human or a robot. Initial stages, all AI algorithms may be helping in diagnosis of your health issue, or what kind of prescriptions have to be given. Then here again comes your personal human rights. Whether your consent has taken in a creating and storing the data there, and whether these data is collected and given to the research institution without your consent, uh, and is there the consent has to be ex ante or ex post facto. So there are many issues of fundamental rights issues are going to come up. These are the areas you need to work on. Yeah, in the areas of agriculture, in the areas of you know, manufacturing or horticulture or use of pesticides, and of course, the hospitals robots are going to play key role if they are going to be used in surgery. And of course, most talked about robot is the automatic cars, which Tesla is going already at the test level. They have done driverless cars. Of course, India is the first country apparently introduced driverless car in Mumbai. You must have read in newspapers, and you know that one car, very expensive car used by the famous Bollywood actor. I'm not giving the car model or actor's name, which ran in the midnight over the pavement and killing half a dozen innocent homeless people. Finally, it was announced that it was a driverless car. So it is not the Elon Musk or Tesla introduced the driverless artificial intelligence car. India, they have already done that. But when these kind of incidents happen, when the driverless car, automation car has come, some accident happen, what should be the criminal law? So you are going to arrest the manufacturer, okay? Then manufacturer says that any problem comes as per the contract sale of this product. If the burden is on the user said there was a software problem, there is a tripping happens sometimes because of that, you know, and that's bad. I gave a command. Those who are using Chat GPT know that, or the Chat GPT is a model called large language model, the algorithm model. There is another model called generative AI models like Stable Diffusion and Midjourney, which creates the music, which ape the voice of Sonu Nigam. Other day Sonu Nigam had his Golden Jubilee birthday, 50th birthday. Yeah. On 50th birthday, you can use any of this generative AI machine and get a new song sung for the celebration of Sonu Nigam birthday in Sonu Nigam voice, mimicking his voice, and which Sonu Nigam physically has not sung to surprise him. That's enough. But if you market it, what happens? Like this, I'm slowly diverting into intellectual property here. The criminal tort laws have to be changed. So not only the regulation point, so regulation which I was mentioning about the US is discussing. EU have a draft bill which most probably which has been introduced in the EU Parliament, and discussion is going on. They may pass it anytime in the last quarter of this year. There will be a law smiling at us. What we are doing? Have we started any sandbox model, or it is too early to introduce a law? Because if you look at the very Chat GPT, the large language model thing, because many people the other days are a disruptive artificial intelligence. But my personal experience is, you know, I'm not a prompt engineer, but whatever a prompts I given to it, whether it is a text prompt or a voice prompt, it has not given me the satisfactory thing. You may ask it to create a document of 1,000 words, 3,000 words, or 5,000 words. It will come out and create it. There are many authors who filed a case in the Supreme Court of US that the whatever scrapping and text data mining it's doing using the natural language processing algorithms or other algorithm language model. So while creating the model, they do learning, collect the information, texting, categorizing from the systematic uh, data, that is the label data, unsystematic data, unlabeled data. If it's a systematic data, the model will be the supervising learning model. Unsystematic data means non-supervising learning model. Then finally, the product is given to you, whatever 1,000 words, 2,000, 3,000 words, you're happy. But you are already an expert in that area on which the ChatGPT is given article. You laugh at it because it has not given complete information despite humongous information available over internet. So what kind of uh, AI ChatGPT has become famous? I don't understand because none of my tests it has given satisfactory information. That is none. That is a big shock to me why people were fond of ChatGPT. Recently, I read an article that ChatGPT people's subscription and paying has come down because of this unsatisfactory work which ChatGPT is. Of course, the case filed about that without permission, it can't create. Learning itself is a reproduction, and then without our consent, and compensation, ChatGPT is not supposed to collect information from my books, copyright protected. That's what the authors are saying. The matter is pending in the US Supreme Court. But my take over that, if you look at the WIPO copyright treaty in 1996, the very article 1 which talks about the reproduction right of the authors of literary and artistic works, which extending the protection given to literary and artistic works of the authors from the Berne Convention 1886, the final revised text of the Paris 1971, to the digital environment in 1996 WIPO Copyright Treaty. The very reproduction of a physical format into digital format is an infringement of copyright. Consent and compensation has to be given. But again, in the Article 10, explaining about the limitations and exceptions, the agreed statement, of course, the three-step has to be followed. Uh, and the only, for example, education research exceptions are given. They are given as per the three-step test. It is a special case. It does not conflict with the commercial exploitation of work by the authors and right owners, and does not prejudicial to the rights of the author. Then coming to the agreed statement, it says, which is a part of the law, international law, as per the Vienna Convention of Law of Treaties, Article 31, which says the interpreting the any article, you have to read the preamble, the number of the article, including the agreed statement. It gives more powers to the member countries to devise new exceptions in the physical environment, not only the existing exception. That's what India have done in 2012 Copyright Amendment, Section 51, subsection 1B, where we drafted that any transient and incidental copy done by your computer network. You are searching a website where copyright content is there, protected content. You are searching that either on your laptop or a desktop, nowadays the tablets and mobile. So automatically when you read for some time and then switch it off, you come back again reading. Automatically when you first attempt, it has done is transient and incidental copy in that your hard disk. So you can't say, the authors can't say that is infringement of copyright. Okay. And that is the exception we are given. So what I've been arguing in my recent US Asia Comparative Law Conference held in Japan, Waseda University, there also I said that this provision is applicable in the artificial intelligence. Authors can't say that chat GPT or anything. The learning model it's creating, after learning, it may created a data set. Okay, that is not infringement of copy. Infringement happens when it is given final product to you. Uh, that is 200 words or 300 words or 500 words. When you've taken that printout, uh, then question comes whether you're doing it for the commercial purposes or non-commercial purposes. If you're doing commercial purposes, obviously you have to take consent and compensation. Non-commercial purposes like education, research, and private writing article is all exemptions are given. But unfortunately, in Indian Copyright Act, we did not foresee in 2012 this kind of disruptive technologies coming and doing all disco dance. So now we need to amend and specifically introduce text data mining exceptions and clearly which EU has done in the EU single digital market economy, copyright economy law, which they have done in 2019, where introduced the text data mining exception for commercial and non-commercial. That helps the people like you doing educational research. You know, right owners will not be sending you legal notice. भैया तुमने मेरा copyright infringement कर number one. Even though it is exception is given, let us say we amend the Copyright Act, introduce exception limitation. Similar way, any research you do, write article, there should not be any plagiarism. So citation should be there, and referencing should be there, as mentioned in the section 52(1)(o) of the Copyright Act. It's one of the fair dealing exceptions for research thing. You know, the citation should be given. Otherwise, it's equivalent to plagiarism. You know, these are the new things are coming. There is two more technologies I want to tell. I think I have a couple of minutes left. One is the metaverse. So what is metaverse? It is a metaverse is a platform where augmented and visual, virtual technologies, augmented technology and virtual technology, going to create a new environment, digital platform. It is a controlled one and decentralized one. Problem with there's no problem in the controlled one because any company has created a metaverse like the Facebook Meta, where you go and create an avatar and doing. So there's not much copyright infringing activity taking place because every time Facebook is needling you there. But when imagine there is a decentralized metaverse is there, where you're creating an avatar which may infringe the copyright of the design or copyright in anything, uh, or you're creating a new environment, let us say that your new building or a new design or a cloth or you are using anyone's trademark there. So all these things. Of course, there is a de minimis thing. A case has happened in the and the EU, the misuse of infringement of trademark in the metaverse. But the court said that is the de minimis. But when you are extensively using, again, consent and compensation has to be given. No, all the present design, trademark, copyright laws are applicable to metaverse. But are there any problems which are not addressed by present laws in the metaverse? So this can be a new area for the research for students like you who are doing a pre-PhD course. You can, it is going to be very romantic and great topic doing research in metaverse. Whether you take a design, a trademark, or copyright. Another important area, that is blockchains. So what is blockchain, Bhaiya? Blockchain is a distributed digital technology. It emerged as a distributed digital technology, a kind of algorithm created basically for the accountancy purposes. Slowly, it gave birth to the Bitcoin. So the creation of blockchain facilitated birth of Bitcoins. Bitcoins totally run by this the blockchain technology. Then from this, it got adopted in various sectors because blockchain basically, once you introduce anything in the block, any information, that is immutable. Just like you can't delete it uh, and rewrite again. Just like your MS Word or Excel, you write something, delete and correct, revise. That's nothing can be done. Once you're written in the block, means end to end, it is block. The data is. It comes with the time stamping. Just like you post something on your social media, Twitter, LinkedIn, Facebook, time is mentioned, day is mentioned. Similar thing happens there. You can't remove. Finish. That's why it's very transparent in accountancy purposes and also the Bitcoin exchange purposes. All that. Anything to be, because it is immutable information and transparent. No one can do the badmashi there, cheating. Then something you legally need to change and introduce a new thing, that has to be introduced in another block. So that old block and this new block get connected. That's called, it end up chain happens. It's called blockchain. Then the new technology comes. Of course, you can discuss how it is being used. Any regulation is happening on the the law in India. We don't accept digital currency, that the bitcoins in India, but the illegally many people started doing. Even Bollywood actors started advertising it, and few have made money, few have lost money. But finally, if I remember, in 2020, government imposed 30% corporate tax on the exchange of these things, bitcoins. But people misunderstood. It means India has legalized this. No, 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 no. Again, finance minister, my ex-boss Nirmala Sitharaman, madam, and RBI governor had to step in and explain, भैया हमने tax impose किया है. We have not legalized this because India believes, just like the physical currency which is issued by the Reserve Bank of India, the digital currency also has to be issued by the Reserve Bank of India, not by Tom, Dick, and Harry, which bitcoins is issued all over the world. So there is a pilot project, been a kind of sandbox pilot project created by the RBI that is being experimented. Once that is successful, they may legalize it in a couple of years. But issuing done by the RBI only, not by any the only RBI means the public sector banks may be following it, and not any private sector will be given norms in that. This is going to be another area. So research, you can give suggestions, and how study the comparative law, how other countries are there. I don't remember any country. Maybe some country must have already introduced legally issued by their central bank, just like India is envisaging. I don't know if that is already been done. If that is the best example to study for you, or you can study in a different way and have a project completed your PhD. Then comes the second part of the Bitcoins, blockchain technology. That is, there is in a three part I'm going to tell you, and briefly I'll finish soon. The second point is, during the COVID lockdown, when we were fearing for our lives, people foolishly running and buying remdesivir and other medicines, even though doctor has not prescribed, and few intelligent, beautiful minds were doing innovation. That's what our national IPR policy is. It's Creative India, Innovative India. What these beautiful minds have done, they gave birth to non-fungible tokens, NFT. So NFT has created a new art form, new platform. This is again based on the blockchain technology. So NFT impacts the design, NFT impacts the trademark, NFT impacts the copyright. This is another. That's why I call it a COVID baby. मैं बोलते रहता हूँ because this technology, this innovation happened during the 2 years, especially the 2021 when that Omicron virus left and right created havoc. The second half of 21, and that time this NFT birth took place. That's why I call it a COVID baby. So this is another beautiful area for the research. And third part of the blockchain. So this, IP offices, you know, many IP offices started experimenting using the blockchain technology, examination, granting patents, or granting examination, granting trademark, or design, or copyright. So most in design and copyright. So just like and also trademark. No one has the record of unregistered trademark, unregistered designs, unregistered copyright. Copyright, is automatic and no need to go for a registration. It's a voluntary, not compulsory. So creating this kind of databases going to help. So what could be the law for this creation of databases? How many countries have done this kind of area? And again, the very IP officers using this. This is another area. Like in one of my talks from the dais of the Jaipur Literary Festival in January 2022, I remember the famous Goa singer, a Bollywood singer from is a Goan. His name is Remo. Remo asked me a question about the how technology can be utilized about the music royalties. I mentioned about the blockchain technology and extended to the publisher because at the time there was a controversy. One author said that publisher was publishing the second print of his book without his knowledge and not paying his royalties. So from using that podium, because my left two top publishers were there, I don't want to give the names of those. Where they are multinational publishers, and no one follows this. Everyone talk about the great things from the diocese and right, but implementation parts, everyone is a free paisa makers. A small kind of cheating happens in all industries. And why should not, when government, you want transparency from the government, why industry doesn't introduce transparency? Tell me. Why can't they introduce by blockchain technology? Because the internet facility where author will log in with his password, see how many books have been printed and distributed to how many booksellers and how many have been sold and what is the amount of money collected by selling these books by the publisher. And as per the agreement, whatever 15 or 20 or 30% royalty meant from कितना मिलेगा उधर दिखना चाहिए. But entire world is not seeing. Only author will see about his books. He will log in and see what is the problem in implementing this technology. So whether this kind of thing, this can be good for in any other businesses. So you can have a look into that if feasible and data available, you can do this. And the last technology before I end my talk, the most emerging disruptive technology is knocking. That is Web 2.0, 3.0. When internet introduced, it is the Web 1.0. We can go and search and download information, read, and all that. When Web 2.0 a kind of interactive thing started happening. You create videos, upload videos. YouTube happened in Web 2.0, and social media happened. Sharing your information, interact happened. It's all centralized internet. Web 1.0 centralized internet. Web 2.0 centralized internet. Web 3.0 going to be different. It is going to be decentralized internet, backing on the blockchain technology. Look at this blockchain, it is everywhere. So without blockchain, when you decentralize, so badmashi hoga everywhere. Already how internet, online piracy and digital fraud uh, and deep fakes. AI has given to deep fakes. Your own video is being made and a typical manner and which where actually or not that. All these things happening when only the blockchain can catch hold of that illegal guy. And that recent new violence. In the new violence, about 8 to 10 WhatsApp groups were created, and entire attack was planned on the procession. Whether, okay, if a procession, there is a goon is participating, people should have gone to the court, got the injunction from the court, and with a direction to the local police that that goon should not be part of the procession, other that peaceful procession go like this. Okay, he may incite a violence or not, but nothing happened. These people go with guns and swords and lathis and attack people, destroy and burn the properties. Everything was planned. And when these kind of technologies come, Web 3.0, it is easy to find out who are the, good and bad everywhere is there. No, I don't want to name any particular religion or a caste or a creed or a sex or a society. Bad elements are everywhere. Sometimes, some area, some places, large numbers come. Some areas, you get only a couple of people will be there. But what I'm saying that, when the new technology Web 3.0, these control can be easily be adopted. So basically, everything is a regulation. What you need to do when these new technology, whichever you're going to do, see, number one, is there any existing law? If the existing law is there, whether it is going to satisfactorily address the issues, or any different examples is a specific laws have been introduced by other nations, whether those can be adoptable. You can do a comparative study. Is there any international law already existing in that? Okay, how it is going to address this, whether India is a member of that treaty or a convention, whether which these provisions have been totally made in how many complaints by law as in India as per the obligation came to India because India signed and ratified the treaty, and then see the how the technology is growing and and what kind of problems are coming. You need to do regulation, intellectual property, and the civil law, criminal law, and most important thing, don't forget about the human rights and fundamental rights. How this will be disturbed with the emergence of these technologies? Are they going to make our lives better? Are going to create any problems for our existence or human rights? Um, good technology, any technology can be used for the good purposes and bad purposes. You take simple knife. A knife can be used for cutting vegetable, fruits, creating art and sketching and doing a sculpture, whatnot. But the same knife can be used to kill your own human brother. So take care of that. And this way you need to research. And finally, I want to tell you, don't indulge in technology law research, emerging technology or emerging technology. intellectual property law research before you understand how technology works. सब लोग बोलते हैं ये आर्टिफिशियल इंटेलिजेंस मेटावर्स ब्लॉकचेन अरे भैया पहले समझो तो लो व्हाट इज एआई ओके एआई का इन्वेंशन क्या होता है इनोवेशन क्या होता है how algorithms are written how software is written how this industry 4.0 technology is emerging so first you understand technology then think about the law okay very good jai hind wish you all the best thank you Dr. Payal once again
Thank you, sir. Jai Hind.
Thank you
Thank
so
you very
much, sir.
much,
Thank
sir.
you. It's
Sir, thank you,
always
sir.
a pleasure
Thank you so much,
listening
sir.
to your lectures. Thank you. So we are not able to see you. I think your camera is off.
Yes, sir.
I don't know. Yes. Participants, if you have any query, you can ask now. Any query, anyone?
Sir, good afternoon. Hello.
Yes, we
yeah,
can
good
hear you.
afternoon
Uh, Sir, you made reference to plagiarism, avoiding plagiarism and all.
yeah, please mention your name who is speaking
Sir, my name is Chetan Dore.
okay
Sir, you made reference to the researchers refraining from plagiarism and all. I have a
yeah
question which is like little different. The other day
yeah
we had an illuminary who had explained about open access. So how
okay
can we deal with open access so as not to uh, be a fact that we are doing plagiarism, sir? Can you just enlighten on that, sir?
yeah my friend Mr. Chetan,
Yes, sir.
I write an article, okay,
Yes, sir.
which is the original work, or I write a book which is an original work, and all references, citations are there, okay. I instead of make commercializing my article in the famous commercial journal where if you want to read my article you have to subscribe
Yes.
make the payment and subscription then you are given the login and password download my article and read instead of that I give it to a open access journal they upload it anyone in the world can open it and read it that is
Yes.
open access
Open access.
without any subscription fee and all that. But when you are writing an article, okay, the same related topic, because it is open access, you can't cut and paste my paragraph and sentences in your article. Okay, you need to give citation and reference. For example, my Oxford University Press Journal of Intellectual Property and Law published in 2019, Origin and Development of Moral Rights in India. It is a subscription journal. Instead of that, publish, let us, hypothetically imagine the same article is in some access, open access journal. Okay. Here, freely available. You need not subscribe to Oxford University Press Magazine Journal of
Right.
Intellectual Property Law. Whether you use material from there or access open access journal, once you read and quoting any sentences from there or anything, you need to give citation, or if you do any cut and paste, it's a plagiarism. Simple.
Yes, sir. Okay, sir.
Yeah.
Thank you, sir. Thank you.
Yeah.
Yes, anyone else has any questions? Any other participants who would like to ask sir any questions?
I think Tanvi, nobody has any question now.
Question.
Yeah, yeah.
Okay, okay. So, sir, we would just like to extend our vote of thanks to you, sir. So, on behalf of Postgraduate Teaching Department of Law, RTMNU, I would like to extend my heartfelt gratitude to you, sir, to share your expertise and knowledge and all these inputs on the very relevant topic in today's day. I think this session will really help many research scholars to decide on their future topics they would like to take. Really, thank you, sir. Thank you very much.
Thank you. Thanks a
Thank you.
lot. And thanks, Payal. Thanks a lot.
Thank you so much, sir. Thank you so much. Thank you.